This video is called No More Right to Silence in New South Wales. Now, I posted a blog on my website last year on the 18th of August 2012 which spoke of the proposed moves at that time to dilute the right to silence in New South Wales. Now, those measures have now come into law as of 1st of September 2013, and what they are an amendment to the Evidence Act, to the New South Wales Evidence Act, and it's embodied in section 89 capital A. What that section says is evidence of silence in criminal proceedings for serious indictable offences. 1. In a criminal proceeding for a serious indictable offence, such unfavourable inferences may be drawn as appear proper from the evidence that, during official questioning in relation to the offence, the defendant failed or refused to mention a fact, A, that the defendant could reasonably have been expected to mention in the circumstances existing at the time, and B, that is relied on in his or her defence in that proceeding. Now, there is a definition in that section of official questioning. Official questioning is when questions are put to the defendant by an investigating official, for example a police officer, who at that time was performing functions in connection with the investigation of the commission or possible commission of a serious indictable offence. So official questioning includes the time of arrest or later at the police station. Now, the definition of a serious indictable offence is as follows. It's an indictable offence. An indictable offence means an offence that can go to the district or Supreme Court, that is punishable by imprisonment for life or for a term of 5 years or more. And really that's most criminal offences in New South Wales. So it sounds like it's only harsh or serious offences, but under the Crimes Act, perhaps most offences are categorised as serious indictable offences. So it covers a very, very broad range of offences. Now, there are provisos to the section. That is, for the prosecution to use evidence of silence against someone, there has to be a couple of things that need to be shown by the prosecution. Now, the first is A special caution was given to the defendant by an investigating official who, at the time of the caution was given, had reasonable cause to suspect that the defendant had committed the serious indictable offence, and, importantly, B, the special caution was given before the failure or refusal to mention the facts, and C, very importantly, the special caution was given in the presence of an Australian legal practitioner who was acting for the defendant at the time. So a lawyer must have been present. And D, the defendant had, before the failure or refusal to mention the facts, been allowed a reasonable opportunity to consult with that Australian legal practitioner in the absence of the investigating official about the general nature and effects of special cautions. So these are the provisos. Now, what is a special caution? What words are required to be said by a police officer to give a special caution? A special caution is as follows. A, the person does not have to say or do anything, but it may harm the person's defence if the person does not mention, when questioned, something the person later relies on in court. And B, anything the person does say or do may be used in evidence. Now, that's the nature of the special caution. That's what police need to say before a person's silence can later be used against that person in court. Now, Parliament's second reading speech, so the speech given by Parliament when discussing this particular law, says that the special caution must be given in the presence of a lawyer, which means that the lawyer must be physically present at the time. So in order for these provisions to be triggered, the lawyer must be there at the police station or must be there at the time of arrest. So the lawyer must be physically there when the person is being asked questions, not just over the phone. Parliament's second reading speech also said that, quote, lawyers may decide it is not in the best interests of their clients to attend the police station because it will trigger the provision. Indeed. Now, what is the effect of all of this? Now, the effects of all of this, in my view, are quite clearly as follows. Firstly, lawyers will simply not attend the police station. That is, when a defendant or a possible defendant, a client, rings the lawyer may well say that, look, it's better for me not to go to the police station, because if I go to the police station, because you're suspected of a serious indictable offence, then you can't remain silent. You can only remain silent if I'm not there. So lawyers won't be there. They won't attend police stations. What will that do? That will mean that defendants, in my view, will not be informed by lawyers about their rights at the police station when under arrest, and they won't be protected by lawyers. And that, in my view, is a very significant problem. They will be essentially at the mercy of the police at the police station. In my view, it will mean that defendants will be pressured by police into making statements at the police station, despite being under extreme stress, anxiety, and having been given very little information about the offence that they're suspected of. So they'll be put under great pressure in an unnatural environment to make statements to police. And in my experience, it's very, very common that police will say things like, look, if you talk, we'll get your side of the story, it'll all be okay. If you talk, we'll give you bail. That is, we'll let you out at the police station. But if you don't talk, things will just be worse for you. Things like that. So people will really be at the mercy of police and will be pressured to give statements. And those statements, because of the person's stress and anxiety levels, may well be extremely unreliable. And of course, those unreliable statements will be used against defendants during the proceedings. So these unreliable types of statements will be used during the proceedings as evidence against the person, and if the person eventually goes to a jury trial, they'll be brought before the juries to suggest that a person is guilty of an offence just because that person stayed silent. And these are very significant problems in my view.